Good morning online. It is 9 o'clock. The English version of it is wake up if you're asleep. But they say in Xhosa, isiXhosa stoliko. The true version of it is vuka mawulele. So wake up. Sibulelani Matima Tabang Katleho. Akona, welcome. Unzu, welcome. What we'll do this morning is do a first session on communication. Once we're done with the session on communication, we'll take a small break and move over to a session on professional conduct. During the session on professional conduct, I'm going to be reading from the Attorney's Code of Conduct. I think it's there on e-leader now. In that class, they printed a version for you if you still have, yeah. You realize it's quite a voluminous document. How many pages is this now? 53 pages, I think, if I'm reading this correctly. But I'll take you through a quick overview so that you look at salient points and things that would at least grab your attention and interest to start looking into this code of conduct and see what's there and how you can use it. It's important for two reasons. One, for you to work in the legal space, but the other reason is for you to understand what the people you are working for are expected to do in their professions. Good morning, Mama. Thank you, thank you. Well, without any further ado, if we were to go into today's lesson, we will look at I hope you have with you what I'm looking at is we should have shared a PDF on module 3, and I'm trying to get myself into that. If you hear me speaking this very slow, it's because I'm trying to get myself into that PDF because I can see it from my side here. All I see is LexisNexis and everybody else. Just disconnect the projector so that I can just have a bearing of where we are. Scroll down. If you are in class, you should be able to go to on your book. I'll tell you now the second portion of it. It's the second portion of it. There, learning outcome 2. It should be on page 14. We need to discuss giving clients legal advice. And when we give clients legal advice, what kind of things we need to do while we are at it. If you're not able to hear me or see what I see, because I have my chat box minimized. Mel has her chat box on. You can say something in the chat box. She'll interrupt me, and then we will see how to fix things. For now, I think everybody's able to see what I'm looking at. Is learning outcome 2, sources of information in order to assist with the inquiry. Now, the discussion is on a client walks into a law firm, and a client comes to inquire on a thing. Of course, the primary things you will start with is what we did in the previous chapter. In the previous chapter, we said you'll take information. You'll get a client intake form. You'll get copies of IDs. You get all those things in place, and you'll be able now to, okay, fine. We've got a file open right in front of us. And probably at this stage, you would have also, if you're working in a law firm, you would have given them a rundown of legal fees. It's important. Discuss money before you even discuss other things, because you don't want after a long discussion you come back and say, by the way, this is what it will cost you. It never works. Have that discussion off the cuff. This is a billable consultation. This is what the consultation fee will cost today. And generally, this is what the firm charges for consultation fee. This is a copy of a generic free agreement. Your office should have a general one. It will show you the fees per hour, photocopies. This is the copy of a generic fee agreement, and you'll be expected to sign one. And if there's any developments as to further fee negotiations between you and the attorneys, you would have a consultation with an attorney who will assist you further on changing a fee agreement. And now we move over to consultation. We call in an attorney, and you are sitting there, and this is the information that we need, you and the attorney. Maybe you're also working with a candidate attorney. If you're working with a candidate attorney, you would be expected to be more useful in the process, because then you gather the information. The candidate attorney might not be that very astute on some of these things, but you've been here in the firm for a very long time, for example, and you need to help along. But please remember, an attorney remains an attorney. Even if the word candidate comes first, you delete candidate, that person is an attorney. So you need to afford them the space and the respect to give legal advice as a legal professional. Your role is to assist them in the process. When you're going to do that, make sure that you have all the information available. This is what I was just saying. You will get that information through what we learned in the previous discussions. Now, sources of this information come from different spaces. If the person has been criminally charged, you would then be able to get in touch with the investigating officer and say, officer, do we have a statement? The officer would say, yes, we have a warning statement, and they would have done a warning statement with the person. Say, may I kindly have a copy of the warning statement? The officer is likely to give you a copy of the warning statement. If not, after bail applications and all of that, the next step is discovery. The state will give you a docket, and in the docket, you're going to find these statements. And most of the time, the consultation in criminal cases I'm talking about is not the consultation pre-bail. Pre-bail, it's a consultation that might happen at a police station. Check with the arresting officer. What is this all about? Why is the client arrested? Do we have a statement? And he says, yeah, this is the warning statement he has signed, and all of those, if any. If none, we say, no. Okay, fine. And then we go through the motions, we consult our client, we talk to the client, and the client will help us to give us information as to what happened. More like the same way you would have done when you are doing the previous chapter, taking details, his name, where he comes from, what happened, does he have another house, does he have another passport, does he have a house in another country, and all those things. Your consultation is bail orientated. You're not worried about whether it's guilty or not. You are more concerned about bail orientation. I've watched the full session on the bail application for the guys on the AKA case. It's on YouTube. So when you get time, please watch it. It will help you to see the both sides. The one side, the state present a full argument with evidence and everything, and the defense come and mount up a defense. Not much of a defense, but at least accused number one mounted some sort of a defense. And everybody else's defense was a little bit thin, but accused number one did mount up as some form of a defense. The last issue that got his case packing was that he claimed that he had a firearm license. The police did a shoddy work not investigating a firearm license. Then the police has committed perjury. The police officer must be arrested. Just when his advocate was done, the advocate of the state stands and say, well, unless my learned colleague has omitted to make available the copy of the firearm license, may he kindly make available the copy of the firearm license. And there I'm sitting thinking, it's not there. So, then he says, no, let me approach. It's not there. Then the next thing, it will be the matter of argument. Brian, there's no firearm license here. So whatever you've been saying all along, they were coming good, And at the end, no, the police must. Hey. Why? Mara, why? This is why you need consultation first. If a client claims he's got a firearm license, say to the client, give me the firearm license. If the client is arrested on drunken driving and he was found without even a driver's license, say, give me the driver's license. The situations, please don't try this at home. I've got two driver's licenses, the expired one and the new one. So if I were to start up a conversation, I pull out the old driver's license and say, here's the driver's license. The traffic cop will say, hey, Mr. Pat, the driver's license expired. Then we start talking. Yeah, and like, I like my photo on the old one. The new one is not nice. So we talk. Then it happens that sometimes I actually forget the one on the other car. Ish. Now that I've developed the habit of this conversation, then we talk. So when we'll give you a ticket one day. And then this conversation goes long. But ish, you must have a charming effect. If you don't have, you'll end up with a 300 rands fine. I'm telling you now. So that discussion goes south if Mr. Pala doesn't really have a driver's license. He has only the expired one and has not renewed the driver's license. It's best for him to say, I have not renewed my driver's license. When the police officers caught me, I was on my way to the traffic department 8 o'clock at night so that I can sleep there. And in the morning, I'll be on the queue. Hey, yeah. And because of load shedding, you had a lot of other stuff. Because of load shedding, that is why I prepared to camp. Hey, my daughter. It's a long story. But then again, if your client is frank and open, you can defend. Now it's only the police now we're standing in front of the court who says, but your client doesn't have a driver's license, Mr. Pan, unless we can produce one. We are waiting. Bring. We can stand down for 2 hours for your client to go fetch it. There's none. And when the police say that they've checked, they've checked the whole database. And they're not telling you a story, it's not there. They're not asking you a question, they're telling you. They walk away. So that is the situation which you then need to deal with. If it's bail, then you move over to this client is now out on bail and he needs to come to the office for consultation. Then you'll have a case file, which will probably have your client statements. Are there any affidavits which the clients have already concluded? You also see on that case that one advocate says, I just received this advocate from my attorney, if I'll be given a chance to come on what on the 15th or something, he said, because I have not had a chance to fully peruse the affidavit. You should see the face of that magistrate there. I could have said the words for him, like, I am very disappointed. Well, he went on and said it. I'm very disappointed. I was also very disappointed. I mean, you are sitting down, the other accused are busy reading their affidavits and everything, all the arguments are going, and you're sitting in court watching this, and you're having your client's affidavit on hand. You should be reading your client affidavit while you're also listening to them. And there's an attorney as well who's taking notes. This guy's not doing it. He was saved by the bell. The state said, no, we don't mind. No objection from us. You know they're winning. No objection from us. You can come at 15. Ultimately, that affidavit was actually very small. I think it was 15 pages. Again, second disappointment. What am I saying? Get this information, make sure that it goes to the attorney on time. From the attorney, it goes on the brief of the advocate on time. And when you call the advocate, say to him, it's only 15 pages, but read it on your way to court. Probably have it as a driver or something. So those kind of things are embarrassing before the court if we don't have the information. So you can see sources of information, make sure that the affidavits are read, and the affidavits, if there's any. Are there any witnesses? Ask your client, did anybody see? So for this to work, your client must tell the truth. If the client will not tell the truth, it won't help. You stole the gold, Peter. Ishbraga, I stole that gold. All right, sharp. Who else saw you stealing the gold? There was some other guys passing. I think it's Simon from Block F. Simon is a witness. If you interfere with Simon, it affects your bail conditions. Those kind of things are very important. So you have to make sure that, are there any eyewitnesses? Sometimes the eyewitness is the one who can help you. He said, but I was not there, like the other accused on the AKA case. He says, I was in hospital being treated for my leg. The other one says, well, I was there, the one who was the spotter in the restaurant, allegedly. He says, I was there sitting waiting for my girlfriend, and my girlfriend never showed up. Okay, fine. Where's the girlfriend? The girlfriend needs to come and say, hey, he was waiting for me, Good luck. If she blue ticked you that day, I don't think she'll come now. So the eyewitnesses are very important. The police docket during a stage called discovery, they'll give you their whole docket. At times it's full of information, relevant and irrelevant, but most importantly, again, to affidavits, the affidavits of their witnesses. You need to put them in order. When a witness comes to give evidence in court and he has deposed an affidavit, your advocate, or at least the attorney who's going to be presenting the case, ought to have read through that affidavit. Because if you have not read through the affidavit, whatever this guy is saying could be different from what is on the affidavit. Photographs of the scene. Well, you need to make sure that the photographs on the crime scene are the ones you get from the police album if they make them available. Alternatively, if you are going to take your own photos, make sure that you get a professional to take photos. I wrote with Mr. Parnell in the IPID manual a chapter on photography, crime scene photography, that's what it's called. Now, crime scene photography, one of the things you need to do is you need a reference or a referral point. If you're going to take the photo of a book, you need a ruler next to the book and then take the photo of the book. If that book was used as a weapon to hit a person, and then allegedly a big book like the AMLA book in the office, it's quite a big book. If you hit somebody with it, they'll be injured. If that book is evidence, or you want to argue that that book is too small that it can kill a person, and the book is available and you want to use that as evidence, you need now to put the book on the table, put a ruler next to the book, and then take the photo of the book. Why? Because there's no dispute as to what is the size of 15 centimeters. And if you don't put that, it will be in dispute as to how big the book is. So it's very important that it must be a true measure, then it avoids arguments. Because if I bring another book and say, yeah, but it looks like this one, but it's not that one. That one, for example, the pages could have been torn and making it further lighter. So measurements are very important when you take crime scene photography. Well, since the book is not available on sale, I can't help you. If you've got a family member who is from the IPD, ask them to give you the book I wrote. It's available at the IPD. You'll be able to check what's happening. And since only Brian classing, one day I'll give you a copy. So that you can see crime scene photography. But that's the thing about photographs. They must have a referral point. It cannot just be a photograph of a coffee mug. The question is, how big is the coffee mug? I could have given you an example we used with Mr. Parnell. You would have laughed and fallen down, but let's leave that example. Physical evidence such as a knife used and the weapon and the gun and all of those things, if they're available in physical evidence. One thing we discussed when we discussed crime scene photography, we were discussing evidence. One thing about evidence is a concept called chain of custody. When evidence moves from one person to another, from one person to another, from one person to another, it could be that the book which was used to hit this person on the head, when it arrived at the police station, they tore some pages. And when it went to 13 for storage, it didn't fit, so they tore some more pages to put it in the envelope. Is this still the same book? No, it's no longer the same evidence. It's been tampered with now a lot. So we need to know who was having this book. Did he receive it in good order? Is the book still the same as the way he found it? And if good order has been affected, then it becomes a problem. Court cases relating to similar facts. A thing about court cases is this. When you came in, Standiwe and I were talking about whether we should change our LexisNexis subscription to add other things on it. And the question we're asking ourselves is, that other subscription, are we really using it? So then it brings me to, if you use Jutastairs, LexisNexis, you are able to find a relevant case law that has got to do with whatever issue you are dealing with. But when you find case law, don't be that legal professional who goes to court armed with the law and the briefcase is full and there's no space to put the facts. I would rather you have to court with a briefcase full of facts and Google full of the law. Because whatever you say, all of us will find the law. But the one thing that proves or disproves a matter is the facts of the matter. You need to apply the facts to the law, not the law to the facts. So even if you were to Google the law, if the law is not relevant to the facts, immediately you will tell that your Googling was not good. But if you come first with the law and you want to force the facts to fit into the law, you've already lost the case. That is why good law is not sophisticated law. Remember, justice is merely truth. So since I've got the benefit of being an investigator in another life, I can then say to you that when you investigate, you are not investigating to find whether a person is guilty or not. You are merely investigating to find the truth. And the truth will tell whether the person is guilty or not. What you are looking for is the truth. What is the truth? And the truth is found in facts like physical evidence. Court cases relating to similar facts help to clarify the facts. You can quote any case law, but if the facts are wrong, it doesn't help. There was one bail hearing we did, and this client lives literally a block away from a police station. And the prosecution says, yeah, your client must go to report twice a week at the police station. And because it's a flight risk and case law, what? By now you could have guessed that attorney being me, I stood and say, but your worship, this guy literally lives in a police station. He passes every morning in front of a police station to work. He goes home, passes away, right in front of a police station, and he greets the police officers. He knows those guys. This guy lives in a police station. Why must he actually be called to report to a place where he lives in? It's a fun fact, but the reality is, now that we all laugh and say, ha ha, Mr. Pala, really? Can a guy really live in a police station? It makes sense. Eh? It's just an inconvenience, guys, really. If the police station want to see the guy, they can go and have lunch with him. Just live next door almost. It's a police criminal or alleged or whatever the case might be, or accused. But he lives next to the police station. Okay, that's our one. No case law. I use facts. So facts helps. Textbooks relating to the subject. You will see me talk to you about, we've actually done it, sources of law in the other module 1. We said court cases, precedents, and textbooks. You will see when, that's why I said go and watch that AKA thing. You will see that the defense quotes Sneyman, I think. And criminal lawyers love doing that a lot. According to page what? Sneyman. The reality is the magistrate knows it. So if you gave me the facts, the magistrate, when he writes a judgment, he will refer to if necessary. You cannot force the law to create a case for you. There must be the facts that assist. And the textbooks help you to understand these facts. But first, start with the facts. Laws and bylaws of the legal rules dealing with such cases. What are the laws around driver's licenses? Like, can Mr. Pala really drive without a driver's license? No, you must have a driver's license. If you don't have it, there must be reasonable belief that if you can go fetch it, you will find it. So there are bylaws. I think it's in the afternoon class, we said there's laws around speed limits. In a freeway, 120, do not exceed 160. Already don't exceed 120. You already exceed 120, you are breaking the law, but you go to 160, you are in jail. So those bylaws, but you now drive coming 120 and it's correct, and you off ramp into Pretoria and you drive again 120, will it work? No, the speed limit in the local community is very different from the one on the freeway. You need to know the laws. And when your client says, I was arrested for just driving, my bra, I got out of the freeway, 120 into Tsamaya Road. It won't work, my melody guy. Tsamaya Road, you can't drive 120 because it's not the freeway. Opinions of experts, especially such as psychologists, if you're going to use an expert, the expert you're using must be an expert. In Pretoria, there's a, now that I've talked of Mamelodi, I'm thinking Mamelodi words now. If you're in Mamelodi, there's a phrase, they say to a person who knows it all, who knows too much. They say, Kitsibing. So don't call Tsibinki to come and explain things. Tsibinki is not an expert, he just knows stuff. But it's not an expert, you see. An expert is somebody with the qualifications, and he has passed at school, he has got experience, he has worked at this. Then that person becomes an expert. It's not, Tsibinki in English is a wise guy. You know that wise guy on the streets. I know, but I can tell you now. No. If you want a coach, get Pizzo. Don't get a guy who thinks he knows soccer. So get the right people. Get Dr. Pizzo Musiman. Hey, maybe you will be able to win. Hey, that team has jinxed. Well, that's criminal cases. How about in civil cases then? There's no issue where we have probably to do two consultations, one at the police station, one at our offices. This one we only do at our offices. The client comes into the office and say, okay, I've got an issue. So one of the old cold cases, a person walks in and they say to you, they call you and say, hey, you know what? I received divorce summons. Yeah? So yes. And then they don't even call them my husband. They say, my ex-husband. It's not an ex yet. It's still a husband. My ex-husband is suing me here. So, okay, it's not your ex, but okay, let's go along with ex. But he also says that I use muti in he's put it in the summons, Mr. Pan. How can he says that he's divorcing me because somebody in the family has died. Then I say, okay, fine. Did he really say in the summons that you use muti? He says, no, he simply says that he's divorcing me because two people in the family has already died already. So where's the muti thing coming in? So Mr. Paladi can only mean that I bewitched them. So we must sue this guy for defamation. Okay, what are we doing now? Are we doing divorce, sister? So we're doing defamation. But I think the thing you're facing right now, you're looking at divorce sermons right now. Can we do this over the phone? It will end in tears. So you say, okay, yeah, okay, I understand. Bring me that copy of the summons. Meet me at the office on this day. Let's have a discussion. Okay, bring along the money for consultation. So I want to be discussing this thing when I'm looking at the rands and cents. This discussion is going to be long. The booty one. Yeah, so we arrive and there'll be those discussions, but ultimately you turn a client to understand that this case they are facing is not the muti case, it's the divorce case. And in divorce matters, even if you put all these other things, it doesn't matter who is right or who is wrong. In the divorce case, the simple principle is this: does the marriage still subsist? Yes or no? Have you lived together in the same house? Have you been sharing the bed together for a long period of time? Are you having disagreements over a thing like the muti then? If those things are there, it's like a checklist. If you guys meet that checklist in the act, you're good for divorce. Let's go. Then we move to the next part. Are there any children? Yes. Oh, my lovely children, I love them. They're staying with me. You know, Sipo, yo, he just bought a polo now. No, they're not children. If you bought a polo, he's not a child anymore. This is an adult. He should be over 18. Yes? Yeah, he's 21. Oh, my baby. No, Silver's not a child. So they don't qualify in this discussion. They're a child, but they're not a child. So they don't qualify for this discussion. So you start trimming the fat and you go to a consultation that brings you to certain points. Of course, if they say, well, somebody is also suing me on defamation of character, like the Basitsana Kumalo case, you've seen that one. It was actually a criminal case. And then the person was now given a house arrest sentence. You need to look at what is the client saying and if there's any statement the client has made. Where do we get the client statements? We get the client statements when the client starts talking, like that telephone conversation. That is the client statement. And I will write it in when I get into the office to say, this is what the client is saying. These are the issues. Are there any affidavits which the clients have already deposed? Some clients, especially the ones who have done LLB and the one who have done BCom law, they tend to think that they know the law. And they go and write their own affidavits. According to Sneyman and Joubert, when they write their own affidavit, they bring and say, here's my affidavit, Mr. Pal. I even passed by the police station to get it commissioned for you. Don't worry about me. I know this law. Read that affidavit with them because they might be admitting to things. Be very careful what is in an affidavit. The same things, the witnesses involved, even in civil cases, there are witnesses. But the moment you use witnesses in civil cases, the situation changes. It's not going to be a motion procedure anymore, you see. It's going to now be an action procedure because now you must issue summons and people must come to court and issue statement. Documents such as policies, contracts, pay slips, letters relating to the case. For example, in deceased estates, we have policies of the deceased, yes. For example, they had a policy. I took a policy on them. And then they also had a policy which I was the beneficiary. What does that have to do with anything, Mr. Pal? I've read somewhere on Facebook that does Facebook still exist? I suppose. I read some on Facebook that if policies don't apply in a deceased estate, okay. Yeah, in layman's terms, they don't. But the problem with it is a person on Facebook talked about the first part of the liquidation and distribution account. It has got a second part. The second part is the part of the estate duty. The estate duty, those policies could be deemed assets. And if they are deemed assets, they are dutiable. And then we have this estate must pay tax on those policies if relevant. And I need to know how much was it dutiable and what happened to it. So if you're dealing with people who think they know, calm them down and help them through the consultation. And they say, yeah, but I know this applies. I understand. Just bring it to me so long so they can just have it as well. That way it will help you to get the information you need from a client. Request information from experts such as specialists, doctors, lawyers, persons, and known experts. We've discussed experts, we've discussed photographs, police dockets. Civil cases, what do they have to do with police dockets? If you're doing a case like unlawful arrest, the evidence which was on the police docket is very relevant. You need that information. Court cases relating to similar facts. I see the word similar facts and my head goes ping, ping, ping. Mr. Pala, you can't say similar facts. You can't say similar facts. Why my head is going ding, ding, no similar facts? Because similar fact evidence is generally not admissible. But what I'm talking about here is not the evidence. So what do I mean by similar facts evidence? You say, well, Sipos came to the office drinking coffee and he was not dismissed. And I'm coming to the office drinking coffee. Now you're calling me for a disciplinary hearing. Oh, well, Sipo got away with it. So, but you didn't get away with it. Who knows? It was even water in that coffee jar. So, similar cases, I mean, similar decided cases, you see what the court has said over this thing, and that does not become similar evidence, it becomes precedence. It's a different story. So court cases make precedence. They don't generally make evidence. Okay, so you've moved over to similar facts, and you now know the difference between precedence, as in decided by the court, and therefore it applies to me. Law must apply the same to all of us. But he did it, therefore I'm doing it, and therefore don't hold me guilty. No, that's similar fact evidence, generally not admissible. Noted issues with SARS. Are there any textbooks that can help you in this matter? Newspaper articles and the internet, not ChatGPT. Laws and bylaws of legal rules dealing with such information. When you're going to gather information, in one way or the other, I've already explained to you the process that you would follow to gather this information. You'd gather this information by talking to a client. Talking to a client, you ask open-ended questions. What happened? Who did it? Where they? How they? And you are able to get facts by asking open-ended questions. Contact an agency and ask them to provide you with required information. The people yesterday in court on that case we were all watching, they could have simply done what? First said to their client, give us your firearm license. And the client says, I've forgotten it at home. They could have simply called the police station to check whether this person has got a firearm license. There's a firearm registry. Even if they couldn't get a license, and they're with the police, it's a criminal case. The police could have quickly helped. But they went gung-ho arguing this thing without the information. Contact the agencies, they will help you with this. Request copies of documentation from persons who are in possession of documentation that is relevant to the case. I'm using that case to get you to go read it, to go watch the video. On that case, as you're going to watch in the video, the state used the evidence of an affidavit in the same courthouse in another case. But the defense said, no, you can't. The affidavit is a copy of an original. Where is the original? We want to see the original. The matter was stood down. The thing was professionally accepted until the state came back later and said, as we said earlier, here is the original, stamped, signed, sealed, delivered. And that was the end of that. So if you get a copy of a document, ask for the original, the whereabouts of the original. Somebody gives you the copy of the birth certificate. In divorce cases, if somebody gives you, says, this is the copy of my child's birth certificate. Okay. In a divorce case, the copy of child birth certificate is good, it will work. Here's the copy of my marriage certificate. Good, it will work for now. But if we're going to go before the copy will not work. The court will ask for the original. But here's also another silly situation. We arrive there and then the other side says, we are not sure even if this is the correct child. I hope they don't do that. Can we see the original of the birth certificate? The court will not be impressed with that kind of discussion because you guys could have discussed this thing earlier. But that as it may, you cannot produce the copy of a document of which you don't have an original. Then do what I have done. If you don't have an original, you only have a copy, and the original is lost, go and make a lost copy affidavit. But in divorce cases, my friend, let your client go to Home Affairs. It's 30 rands to print a copy. Then your client must come to court with a copy. So when they give you an original marriage certificate at the office, you make a consultation. Say to them, sister, this marriage certificate is likely to be lost. And they go like, oh, yeah. So to safeguard yourself, you should consider this lost. If I were you, I'll go to Home Affairs and print another one to avoid delaying things. It's very likely to be lost there. How do you gather this information? Get information from a library. These days, you can actually email the library, and the library can email you back and give you information. Consult experts. If you're talking about road accident fund, you need the medical report from a specialist. Please make sure it's not a GP. Ne? Get a specialist to write this thing. Yeah. Make sure you get a proper specialist. If I were you, I'll get the one who actually works with these things. He's not taking chances. He's done this before. And then he will give you the medical reports, get the medical reports filed, and then you attach them there. I have seen a discussion about, I think it's a case on the road accident form. Is it rough one? They'd introduced a new one. They said when you do it, you must attach things. I think they also wanted the medical reports to be attached and everything else before you submit. There's a court case last week that said that form, the new one, is not good. It interferes with the rights of the applicants. And therefore, the old way of applying for RAF is good enough until the minister has considered the new way and publish it in such a way that it doesn't interfere. So those, go back to your office, look at the last week applications you made, and RAF said, rejected, rejected. You didn't attach this and this. Check if it complied with the old ways. If it complied with the old ways of doing your RAF application, that application is well and good. Go back to RAF. If I were you, I'll look for that case and print the whole thing. So go with the fire, go with the case, say, buka la. The Kantolo has spoken. Put my case. And then the case will be put back into the application at RAF. Just make sure that you cross the T's and you dot the I's. Make sure that you follow the processes. But if your office has been using the new forms, the new methods, that very same case said it's good as well. You can proceed and do what you were doing. But it's just that for the people who are not legally represented, somebody just goes and finds on Facebook the road accident fund form, download it, fill it, and go and apply himself. No attorney, no nothing. And then they arrive there and say no, and they don't tell you immediately. They tell after some time, say, sorry, your application is not good because you didn't fill the correct form, or you didn't bring the things that is required by the new forms. If the person has come to your office complaining, it falls in that category, check if it's not covered by that case law. It's I think I was reading this on Good Friday. So it should be a Thursday, Wednesday case. So when people go to church, we read cases, find it. It was posted by, if you work in a law firm, check with the attorneys, they have it. It was sent to all of the attorneys by the Legal Practice Council. Let them check their emails. You'll find one. But once you get the information, This information needs to be evaluated. 10 minutes to break. You need to evaluate this information. A client comes and he gives you a piece of document and he says, I'm telling you, Mr. Pala, this thing is a contract between us and the other party. You must submit it as evidence. It will escapate me. It will make me free from what I'm being accused of. I look at the document. I look at the client. I look at the document again. Okay, sure, it has the signature of the other person accusing the client. But I look at the client again. While I might see the signatures, it's my client. This client, I don't trust. So I'm not going to rush in there and say, go to court and say, here's the document. Your Lordship, my client is, what if the other person comes and says, it's not my signature? You are sitting now at fraud point 2.0. I'm good with fraud 1.1. 1.2 is a problem. So to avoid such situations, you don't rush. You take this document and you look at the signatures of the person has signed on the other documents. If those signatures are at least generally the same, you're not a signature expert, but if they're just generally the same, you go with that document and you will use it in evidence. But further, if you are in Limpopo and you are in Venda, the Venda language has got something. It's an English word, but that English word has found itself in the Venda language. They say, "Niataimisa." Utaimisa is to, you can tell it's time. Right? It's like you're using time. Utaimisa is to, you stand and observe, and if the time is right, you use it. In Venda, they say do time means. So you need to do that. So check the documents sent also by the other parties to you, like the discovery documents from the police. Check the other signature the other person has, not only from what that client is giving you, but what the police is giving you. Those signatures that they say document is good. And also listen in court. If the person says, yeah, and we met and we signed the agreement, of course. Well, they are giving their own evidence because your client has not started giving the evidence. You say, now strike two. Yes, this document is now authentic. From your client, from the signatures, from what the other party is saying. When you now present the client's case, you say, we have, your Lordship, also this document in evidence. You have now sorted out the issue of you not trusting your client. They're accused of fraud after all. Yes. Eat your food, but put a bit of salt. It's your food, but take it with a pinch of salt. So that's what this is all about. Verify what the client has given you. Driver's license from Mr. Pala, verify if it has not expired. These things are important. Sufficient information, make sure that the information is sufficient. And I'm taking you back to that. Why am I thinking Senzumi? I'm taking you back to that AKA case. If you're in Pretoria, you've got time, one day you are bored, walk into that Senzumi, your trial, spend 10 minutes there and enjoy the arguments. The argument there was about a firearm license. And the advocate is adamant. So he shows and he says, yeah, here's the competency certificate. Here's the certificate to show that my client has trained. Well, the competency certificate and the certificate from a training college showing you that you have trained in firearms, it's not a firearm license. Firearm license is the third thing. It means while the person could have been trained in firearms, it is not sufficient for him to hold a firearm, or it is the right words, to possess a firearm. For him to possess it, it must be licensed. For him to use it, he must be trained, yeah? But for him to possess it, it must be licensed. And of course, use is very linked to possession. How then do you use a firearm which you're not licensed to? You remember the Julius Malema situation, firearm fired somewhere at a rally? I think it was they claimed it was an AK-47 or something like that, or something of an automatic rifle. The issue also turns on who owns that firearm? If Julius fired it, for starters, does he even have a competency to fire such a firearm? If he had, do you really fire automatic rifle in the air? No. I'll leave it to Julius. Hello, Julius. So then, sufficient information. What is the name, address of the person who's driving the vehicle? Will tell, for example, if you're looking at the road accident fund applications. I've given you a breakdown here, but you can add more, right? But you can use my checklist for road accident applications. Another place to help you with this, you know where I harvested this information, and whoever was writing this harvested this, is from the RAF road accident fund form. It tells you the things they want. So take those things and create your own checklist, so that when you are dealing now with a road accident matter, you know exactly that it fits the entire checklist. That concludes what you would have learned in Learning Unit 2. Just to wrap up in 5 minutes, what is in Learning Unit 2? In Learning Unit 2 is the information you use when you're going to assist a client. When you're going to assist a criminal law client or criminal matter client, you must keep it at the back of your mind that you'd have two types of consultations. The one could be immediately when the client is arrested, it's got to do with bail. The other one could be to do with defense. And then by that time, you should have discovery affidavits and all those documents. And then you can make research based on all those. And we have said, remember, do not start with the law, start with the facts. Then find the law to supplement your argument. Then civil cases. In civil cases, you probably generally have the one consultation. But this consultation, it does not just start as a consultation. It starts with, hello, is that Mr. Pala? Yes. My ex is suing me. He says I use Muti to kill his relatives. He put it in the Samots. That conversation is the statement of the client. The statement of the client further leads to you saying, okay, I hear you. Can we meet on this day? We have a consultation. And when you arrive at the office, you'll find Standyway will offer you coffee and all of that discussion. And then they come, we have a consultation, they're done. Then at consultation, we get information that assists us to whether do we go with defamation, or is this client really facing a divorce matter? And then we either deal with divorce or even both. We can even deal with the defamation issue. So once this information is given to you, I've given you an example of a document like a contract, which you look at this client, fraud, client, fraud, client. I'm not just going to believe it. I will make sure that I test whether this document is authentic by using other documents, but also using the vendor approach. After timing things to make sure that it happens, then you introduce the evidence. Do not rush. You want the attorneys in your firm, you want the advocates which you are briefing, that you can use this document, but be careful about its use. If you've been following one of the cases we were doing on YouTube, you'll see that he has sometimes, just watch, the introduction of these documents at times, they become a trial within a trial. and we start arguing admissibility of a document, it becomes a long issue about it. Then ultimately the court must rule whether that document is admissible or not. In most instances, we will be gentlemen enough and say, okay, fine, can we get it provisionally admitted? And then we'll prove our story at the later stage. Everybody says, fine, fine. We walk away. And we later then come and check whether our story checks out. And if it doesn't check out, your lordship, let it be withdrawn. If our story checks in, it's exhibit D5. So those are the things that happen with evidence and clients and assisting clients. Ladies and gentlemen, in the absence of anything strange, go take your time, walk around, move around the offices. You'll be back 10:30 so that we can do at 10:30. We go through the government gazette that says the legal practice code of conduct. Thank you very much. I'll see you rather a bit later at 10:30. But can you check with Mel that the document we are using, she printed, if she can email me the exact copy she used. I'm just trying to avoid to download it and it's not exactly the same thing. Yeah, because I'm having a hard copy here. I want to flight it on for the class when we return. Okay, so we should be back, and you should be having a code of conduct with you. We will start with Sumanti. You wanted to ask a question about funeral claims? Let's get on with the funeral claims. You can unmute yourself and ask, or you can type it in the box. Let's see how far we can get done with it. Okay, so the road accident fund is a creature of statute. So when they deal with anything that they change or not change, they cannot change it off the cuff. It has to be on a gazette, or it must at least be on a notice. If there's no notice or gazette, then those funeral claims are due and payable. If they are saying to you they are kept, they must show you where is it gazetted, or at least a notice stating it. You want to start that fight, you have to drag them all the way to court, because then they will be adamant. The current rough guys are not that very nice in settling things amicably. So if you want to start that fight, take it up to court, and I think you can even do it on agency, especially if the family is now struggling, they need the money to take your children to school. You hear me? I'm bringing the reason of agency is that you need the money to take the children to school. Education has always been an agency thing. Have it dealt with that way. Say, send them a formal letter and ask them for the reasons for their refusal, and those reasons must be backed up by the government gazette or by a notice. If none exist, take them to court. And when you take them to court, the attorneys will deal with it. But the first thing to take them to court is to ask them to furnish the reason for their decision within 30 days, because it's an administrative decision. So they'll follow that process. It won't take us, it's not a too long legal process. So we'll follow that and then use a court rule that says that they need to furnish the reason for the administrative action to your offices within a certain number of days. At the top of my head, I'm thinking 30 days, because I'm doing another matter where we have said that to another administrator. failure which, and the court, you go to court and the court will compel them to give the reasons. And if those no reasons are not plausible, it will then be ruled unfair administrative action, and the decision will be set aside. They will not only pay the compensation, but they'll also have to pay the legal costs. I would say, as they say in my office, I don't know if you guys use a language like that. Request with a gun to their head. So say to them, if you don't, we will litigate. So if you request nicely, they never listen. Request with a or else, and use that letter as an attachment to the affidavit that you did request, because this will be on an application procedure. All right, so we are on the code of conduct. It is for attorneys, advocates, and legal practitioners who do not practice in the ordinary sense. The most important, the starting part you shouldn't ignore is the definitions. It helps you to understand what this legal profession is about. It has got the general provisions, which discuss generally what should happen in practice. It has got the conduct of advocates contemplated in the Act, and it has got conduct of legal practitioners and candidate attorneys. It is the conduct of legal practitioners not in private practice. That is attorneys or legal practitioners working for government. That is also your prosecutors and things. Generally, it tells us how we behave with each other, how we behave with the public, and how we behave with the courts. It covers generally our behavioral conduct. I'll take you through samples. First, our human conduct. For example, it has got things around sexual harassment and all of that, but also courtesy. But it also covers money, because the disputes that you'll find a lot with the legal practice council has got to do with money. And it also has got to do with briefs also, and instructions. When you take an instruction, you should be able to do the instruction. And if you do the instruction, make sure that you do the instruction as reasonably quick as possible. So to get us started with the samples of what we are talking about, let's go to 3.11. Starting at 3.10, actually, advise the client the earliest possible opportunity on their likely success of such clients' cases and not generate unnecessary work nor involve their clients in unnecessary expense. So what we are then saying is, when you gather the information, you look at it and you see if this person will be able to have a claim or not. Otherwise, you're just generating unnecessary expense. There are some things like road accident fund we are talking about now. There's the claims they accept and the claims they do not accept. They've got thresholds, a certain percentage of the whole body impairment and all of those. They don't do whiplashes and things. So you need to be aware of what they cover and what they don't cover. They are in insurance after all. So you should be familiar with what they cover and what they don't cover, and you don't take your client on a wild goose chase. There's also a situation where a client comes to you and say, the other attorney, I've taken him to the legal practice council. He has not paid me. The legal practice council ruled that it should be taken to the legal, I'm just going to say legal practice council fidelity fund. I'm hoping that I'm quoting the fund properly. The one thing you will learn, and I've learned it the hard way, is that the legal practice council fidelity fund is a fund of last resort, which means you must sue the other attorney first, and only then, in the event that that attorney cannot be found or the attorney does not have money, is when you can approach the fidelity fund. But you don't go to the fidelity fund unless you have exhausted all internal remedies and all the other methods you can do to get your money. So you need to advise your client of this. You must not have high hopes that you'll get the money tomorrow. It's a long, involved process. Use their best efforts to carry out work in competent and timely manner and not take on work which they do not reasonably believe. You see, there was an old man who taught me to write books, Mr. Van Roy, and it's now passed on. He would always say when we write, he says, Ruby, don't use end. So, so if you see anything I've drafted, there's very little end in between. I don't use conjectures, but you also see a lot of these. So my point being that end joins two different ideas at times. Like in this sentence, it actually joins two things. The first thing, though, is use their best efforts to carry out work in a competent and timely manner. Full stop. That's where my story with my old mentor comes in. This thing should have had a full stop here, and it started a second one. You are paralegals. Making sure that work gets done and gets done fast starts with you. If you were anywhere between me and my team, if you were to walk into class, you'd hear me say, contact that person, I want that information and I want it now. Because the client is also doing the same. Mr. Pala, I need to be helped and I need to be helped now. I know you've got many cases, but my problem is my problem now. So if you can't help the client, be fair and say, we can't help you now. You can bring your matter to us in 3 months' time. We can help you if possible, or go to another attorney. There's another law firm in Wheatbank. It's run by an old man. He deals with civil cases, rough matters, medical negligence, and things like that. When you walk in there, he says, well, my friend, I've got a caseload for the next 8 years. If you want me to do your case, I can put you on the diary, but you can only come in the next 8 years. Then, yeah, no, thanks, uncle. Okay. 8 years, no, we can't do the next 8 years. So that's him telling you that no, he cannot help you now. So the second part of the end, where I said they should have put a full stop there, should be a full stop. They take on work which they do not reasonably believe they will not be able to carry out in that manner. So if you cannot do it, don't take the instruction. Because now you have to call other attorneys to help you and all of those. Advocates are specialized. They do certain special work. Attorneys, they're like general practitioners. But if you're a GP, also be a GP who deals with certain things. You can't be a jack of all trades. There are things you are good at. Like I always say, if I do a criminal case, you would find me doing commercial crimes court cases. If you find me the magistrate court, I'm likely doing a civil case or a fraud case or something of a nature. I don't do cases where somebody has stabbed somebody with a knife, and no, it's not my kind of world. I don't. I'll get my colleagues to deal with that. They will contact the police, and oh, I don't have the patience. I'm more of a corporate lawyer. So even if I'm going to a criminal court, I go to clean criminal cases, to, suits. Yeah, that's me. Yeah, yeah. I don't chase buffet. So that's the 3.11. 3.12. Be entitled to a reasonable fee. Now, it's very, you'll find that your law firms have got a fee structure, right? They put it there. It depends. It depends on location. It depends on many, many things. It depends on whether the client gets coffee and bottled water and aircon. And many things influence this thing. Because if criminal lawyer, you met him in court, 800 rand an hour, I think. Something like that. Yeah, it'll help you. You come to us, it's not going to fly. If you pay 2.5, you're a lucky person. That's because these corporate lawyers, they charge a premium. You could also see the offices they operate and what they do, how they research stuff, things they send you. It's involved, and they deal with these high profile matters. And don't feel offended when you come and then I say to you, I hear you, my friend. Can I please send you to a lawyer in town? Can I help you? I'm sending you to your own size. You can be helped there. Does your law firm have remember, law firms can accept, lawyers can accept an instruction or reject one. They're not like advocates. Advocates, if they are available and is their field, they ought to take the instruction. They have an obligation to take instruction. You take an instruction, one, you can do. Two, you can afford. If that client can afford you as an attorney, be fair and honest. Because the next thing you know, you don't do that work very seriously because the ones are paying you a lot of money. The bank and other people are paying you a lot of money, and you are now not taking care of Mrs. Mazibuko, who's only paying you 500 rands. Be fair. Otherwise, do a pro bono case. Say to her, Ms. Mazibuko, I feel you, eh? Pull an Italian thing. Miss Mazibuko, your money is not good here, eh? Mr. Mazibuko, you are a member of the community. Ms. Mazibuko will help you. You pay your own staplers and printing costs and other things. But as for legal fees, Ms. Mazibuko, pro bono. Do them for free. So later, don't be a dollar. And then you help her. That way, no issues. You go to 3.13, remain reasonably abreast on legal developments. So I've picked these things, 3.3, that you'll see me talk legal research with you at a later stage. You'll see me talk to you about subscriptions, and I've said this to you. Go to LexisNexis, subscribe to things, receive emails that tell you what cases in a special field of work you do. Subscribe to Judah. I think they send Judah reports every month, the cases which were done of interest in a month. I think that thing is free or something. I'm receiving it. I don't know if I'm getting it for free or not, but just make sure that check if it's free, subscribe. You'll be able to be aware of the cases in your field of work. If there's cases of interest in your field of work, follow them. Like I'm following your AKA case more than I would follow your Senzo Meiwa case. Sense of Miwa case, I see as in violence. The AKA case is violence, but I see it's a money case. It's you want to see how the money situation has led to this. There's a case now at University of Port Hare or something in the Eastern Cape. It is also a money case. The former AKA bodyguard is involved, which makes me wonder whether these accused are the real accused. If his bodyguard was actually not involved in this whole story. Sorry, bodyguard, but it makes me wonder. But those are the things we need to look at. So we go also to 3.14. 3.13, I said research, get the developments, know what is happening. 3.14, behave. See, it's still the first word there. How you behave towards colleagues, behave. Learn to behave properly. Look, we've got different personalities. You can tell my personality is very bubbly, nice, and everything. I don't do serious. I know I don't. But there are boundaries. Respect presiding officers, respect colleagues. In one case, I would walk in and I greeted the prosecutors. Everybody said, so you greet the opposition. Oh, well, I might work for the NPA one day, so this could be my colleagues, plus and his captain. So I greet everybody when I walk to court. I greet the stenographer. I greet the cleaner and everybody. Just have that personality. We are the same, but find what works with you and be nice with everybody if you can. And if you can't, be cordial with everybody. It's very important. Understand that you also behave with colleagues. We are not enemies. Remember, our clients are the ones who are fighting. We are not. We'll argue a case. After we argue a case, we'll go and drink coffee. Since you are the ones having a problem, we don't have a problem. The other case, we might even do it together. That attorney of yours might also be a correspondent attorney for me in the future. So be nice. We are colleagues. So do not be nasty. You see, I'm talking to you in a very low level discussion. Don't be nasty to other people because you don't know who you will need tomorrow. In the legal profession, we need each other. Be nice, including the cleaners. They know the things you don't know. Legal practitioners, members of the public, you must also act with integrity. If you don't have the document, say, colleague, I don't have it. And you send the matter down and go and get it. Or I check with my client. If he has, then we take. Be straight with your colleagues. I found out it's easy to defend the truth than to defend a lie. Be straight out. This is where I stand, and this is my position. Be honest, be straight. Of course, some things keep to yourself, but if you have to discuss something, be honest. If you don't have the original of the copy and the document is lost, colleague, I don't have it. Can I go and make a lost document affidavit? He says, no, don't worry, we'll do it later. But at least you have his buy-in or her buy-in. It's important. Be fair. I've done cross-examinations where I see that, la, I'm winning. This is 10 not. Then I say, ish, in fairness, let me not ask you further questions. That will be all, my lord. No further questions. I mean, this one, the more I ask him questions, the more he digs a hole. If you win, win graciously, my point is. Win, but win graciously. Yeah, well, it's important. Don't be like Baroque after they beat Sundowns. They go, They run all over the stage. Yeah. Win nicely. Yes, sir. And experience, what you are saying, and experience counts. You know when you have won. How do I say it? There's there's a book on cross-examination. Actually, I'm reading two of them. It says the best cross-examination is when you ask less questions, not more. If the police officers say, we went to a house, we obtained a search warrant to check whether Mr. X had firearms in his house, and he comes, that police officer is on the stand, and you are very sure that they didn't find the firearms, is it okay to now cross-examine him and say, you went there 10 o'clock, didn't you? Yes. You went there and never read my client's his rights, didn't you? Yes. Okay, it's relevant questions, but the point here is, if it were me, I would say, this, Colonel, this is your affidavit. You will say, yes. Colonel, right at the bottom of the affidavit, you said you were obtaining this affidavit to check whether there are firearms in my client's possession. He says, yes. Well, Colonel, in all fairness, you didn't find anything. He says, yes. Then I sit down and say, that's all, Your Worship. Because he went there to find, if he didn't find anything, then there's anything to. But we could have spent an hour going other stories and other things and other arguments. But it's not relevant. You are winning, dude. Win graciously. Win nicely. Yeah. Don't run around the whole soccer field. Okay. So refrain from doing anything which could or might bring legal. Okay. 3.15 explains my story. Don't bring the legal profession into disrepute. That let the poor policeman save face. He's still a policeman after all. He's still a policeman after all. He agreed with you, your client can go home. But to embarrass him while you're at it doesn't help. The Zulu of it is kahle ngodlame. So if you're going to cross-examine, avoid violence. Yeah. Sometimes it's necessary, but just don't start with violence. Be nice. If it's necessary, go and say, Colonel, didn't you say you've got 30 years experience? Yes. Colonel, what you have done here doesn't show any experience. That's it. Yeah. But just reserve violence when it's absolutely necessary. Don't go around harassing police officers. Well, go to 9. The whole 9, it's about integrity in performance of professional service. It's explained in everything. They put a lot of points there. 9.1, prevent suspicions. 9.2, do not advise your client to break the law. Remember, all legal practitioners, including you paralegals, we are the servants of the court. We must not allow a situation where we make people to break the law. You have seen this in the accounting profession. Even SARS now is saying it, that there are accounting professionals who assist people to pay less tax, and it's not right. Help them lawfully, but unlawfully, no. Help them avoid paying unnecessary tax lawfully, but making them avoid tax is not good. They must pay tax. In the legal profession, our clients trust us wholeheartedly. We shouldn't advise our clients to break the law. That is what point 9 is about. You can read the whole of it. Do not take bribes. So, yeah, don't take cold drinks. All attorneys ought to drink coffee. Stay away from cold drinks. Go to 16 as we will be rounding off. I'm just going to give you 2 more examples. Can you see 16 talk about communications, replying to communication? It involves you. You'll be writing letters, sending emails, and all of those. See, when do they expect you to do this? To do it timelessly. Do not miss communication to clients. Inform clients, send emails on time. When we say send that email to the client, don't say, well, I will. And then I come 2 days. Did you send the email? Oops, I forgot. It doesn't fly. You need to send emails to the client timelessly and practically immediately. It's very important. It's in the attorney's code of conduct. You need to respond to clients reasonably. And in the advent of WhatsApp, when the client sends a WhatsApp, they're sitting there and hoping for an answer. They're going ramming on the table, hoping that you respond. It's good to say, if you are the paralegal, to say, well, Mr. Pala is not available right now. He'll contact you later. It helps. And at the later time, then I contact the client, we talk, and the client is happy, thanks you, and we move right along. And the last 2 things, the other one is appearances in court. I will leave that out. I will not bother you with it. Go to section 59. It's right at the bottom of things. Before we go, 59. Conflicts of interest. Can you see? It becomes an issue. Sometimes you represent 2 people and then their issues become, how do they say it in Will Smith? They become entangled. The moment they have an entanglement, call them and say, hey, guys, we must choose who I go with, and then you need to find another attorney because your issues are now cross-wired. Or leave the both of them and say the both of you now need to find separate legal representatives because, hey, guys, can't represent you both. Your issues are cross-wired and I'm caught in the middle. There will be times like that, especially if you represent a group of accused. If there is an issue like that, you need to call all of them to sit down with you, and then you hear whether they're going to proceed and how they're going to cure that conflict if there's a conflict issue. But also, conflict of interest is do not represent your client's opponents in a matter similar to the same. You've done the divorce case, and now the other party comes and say, yeah, come and do the maintenance. You see, it's never going to work. Your client is your client, but your client is your client. Because when you're doing a divorce, you're also going to discuss maintenance issues. And you cannot now later do the variation of the very same maintenance order you took on the other matter. So when clients like that come, and you as paralegals, because you receive these clients first, say, but, oh, are you not Mr. Mahlangu? Your ex-wife, Mrs. Mahlangu, says, yes, you guys were very good in court. You beat me. Now I want you to represent me against that woman. Say, but say we can't. Then we call the attorney to clarify, but I believe we can. Unless if there's any other matter that's got nothing to do with your ex-wife. This is important. There's a whole lot you can learn from the code of conduct. But in most instances, you see that we expect you as a person who works in a law firm to follow our professional, including how we dress, by the way. Attorneys dress in a particular way. Learn the dress code of your environment and dress the same way the attorneys dress, because you work in a legal space. When a person walks in, they are going to a law firm. They are not going to a paralegal who will introduce them to a lawyer. They're going to a law firm. So the expectations is, okay, let me do housekeeping. How you dress is very important. Dress professionally and courteously, professional dress code. Grooming, look nice at all times, because when people see you, first impressions last. They see the company. Behavior, behave. I've said it the other side. Behavior, as in most instances, you find that people who are in the paralegal space, some are young, and you want to behave like youth. You want to walk into the office and you laugh. Yeah, it works in high school, but not at work. It's a professional space. You need to curb how you laugh. Learn to laugh professionally. Yeah, laugh in syllables. Yes, learn how to laugh professionally. Learn to shake hands. Those are the things that come. Learn to pause and greet people. I've said I greet everybody at court. Do that. Learn to greet people. Start now with the waiters and waitresses in restaurants. They approach you, take special interest. Say, hi, Nobuhle, how are you? I'm fine. I'll be your waitress for today. I am very grateful. What do we eat? And they'll give you a menu to read. Say, no, you know the shop better. Tell me. They'll advise you. Yeah, they will really advise you and show you the nice things to eat. Don't eat this one. Try this one. And then you talk the next thing. Tip them the best you can. They work very hard at it. They make a mistake, be nice. I have these whole lot of celebrity friends, and we go to restaurant, you see it, and a waiter, waitress makes a mistake. Then they jump off on that person. How can you do something like that? You must show professionalism, man. When you, it's not necessary. It's just not necessary. Maybe this person's child died. There was a funeral on Saturday, and she's now coming back to work on Monday, and her mind is right not in the proper space. And you get off because they are waitress. No, pick people your own size. Try me. Let's see if it will work. I don't edit tears. It won't work. But you see, be courteous when you deal with people, especially those people who are considered lower people in society. When you go to court, be nice to the security guys who check your bags and things. If you get nice, next time when you go to court, like what happens with me, they say, "Hey, Mr. Pala, pass, 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 pass." And then you also pass. So, where are you going? Then you take out the things in your pocket. But Mr. Pala just passed and he went beep. they have their own people. So be courteous with people. They'll treat you well if you treat them well. If you serve at Road Accident Fund, government departments like this, the state attorneys, the clerks of the court, be nice. Take time, stop, ask her name, talk to her. Children's advocate, talk to Dani there. And if you go to Pretoria, talk to her nicely. She will help. She's the one who taught me how to write a settlement agreement for children. So if you talk to people, they'll be able to help. And it's me pontifying for kindness, but be kind. And of course, one day you too will not be in a good mood and people will forgive you for that day. Ladies and gentlemen, thank you very much for attending. Nice seeing you. We're doing a session on Saturday on it's a session that we need to do activity. Is it this Saturday? If you can come, I believe I'll be here. You can come. If you can't come, connect online. The one we are doing this week doesn't really need you to come because I'll be taking you through assessments. So I'll put them on the YouTube things. It's how many hours? 2 hours. So I'll take you through assessments from 9 o'clock to 11. So I'll take you through assessments, go through the assessments with you, show how they work, how to complete them. I'll also assist you maybe to complete 1 or 2 assessments. But I'll get you started on doing assessments because ultimately you want a certificate. For you to get a certificate, you should do the activities and do the assessments. And I'll assist you this weekend on how to do the assessments. Please, if you can, log in at 9. If you can't, I think it should be recorded. Get the recording along, and then we can take it from there. If we do live activities that needs like mood court and things, I'll tell you. But this weekend one won't do it. Next week, Tuesday, we don't have a class. It will be on Monday. It will be on Monday. You need to connect online. It will be 5 o'clock. I'm hot booked the whole of most of next week, so I'm not really available. But we'll do a session with you on a Monday, 5 o'clock. Please join the 5 o'clock session. It would be nice to join up with the other group. If you can't, please also get the recording. It will also be available. Thank you very much, Tania. Nice to see you guys. Goodbye.